Epitome IAS. So we were discussing about answer writing program and how to write answers effectively, particularly in the context of the UPSC mains questions. Okay, so this is also a question that is picked from 2025 General Studies paper 2. So in which there was a 10-marker question. So regarding the administrative tribunals in its comparison with the judicial system, how is it advantageous, and what are the reforms that were made in the 2021 and what is its impact. This is what the overall essence of this question, right? So we need to understand certain things. First of all, the fundamental aspects must be clearly there in the mind, right? First of all, what must be the introduction? Okay, so the introduction is pertaining to tribunals. What are the tribunals? Okay, so tribunals are quasi judicial bodies which are constituted under a statute enacted by legislature. Okay, statute enacted by legislature which offer the quick and cost effective resolution of the disputes. So this is how we need to write the introduction. Okay, right. So the question is about administrative tribunals. How administrative tribunals are advantageous? We can write these are the administrative tribunals. Okay, right. And of course we need to write constituted under statute enacted by legislature which offer the quick and cost effective resolution of disputes in the administrative matters. In the administrative matters. Okay, so this is how we need to write the introduction, right? After writing this introduction, what we need to write? We need to write the what is the purpose of, what is the need of the tribunals in comparison with the judiciary. Okay, so before we write something about the purpose of the tribunals in comparison with the judiciary, let us understand certain things. Okay, so here we need to keep certain things in the mind when you are going to write answer. Okay, so this is not part of answer, but I would like to give some clarity. Okay, right. What is it? The after economic reforms in 1991, what happened? The governance paradigm has started. What is it? The paradigm of governance. Okay, this governance paradigm actively involves or makes private sector as partners in development process. Partners in the development process is even market. Okay, market, civil society and other organizations. So when market is involved, definitely the role of private sector is so critical for the achievement of the goals of the state. So, but you understand, this paradigm must also be addressing the effective resolution of disputes. The dispute resolution is very, very important. Why? Because if dispute resolution is not faster enough, definitely it does not lead to better competitiveness in the market, or sometimes the investment may be locked in the dispute for the years together. So that will be having the impact on ease of doing business, right? That's the reason why we have established a tribunal system, particularly by 42nd Constitutional Amendment Act of 1976. We have added Article 323A and 323B. Okay, so these are the two articles are added, and Article 323A is about administrative matters, that means service conditions and related matters, and Article 323B is related to tribunals for other matters. So we need to understand here the examiner asked about administrative tribunals. Okay, so here administrative tribunals not necessarily only tribunals belonging to the category of Article 323A. Those tribunals, according to the intention of the examiner, those tribunals which are related to administrative matters, not necessarily the matters related to the service conditions, not necessarily the matters related to the service conditions, right. So we need to write these points. Okay, so by the 42nd Constitutional Amendment Act of 1976, there is a provision added, Article 323A and Article 323B, pertaining to the tribunal system in the country. Okay, right. And then we need to address the demand of the question, right. What is the need for administrative tribunals in comparison with the judicial system? Okay, what is a need? Right. So we need to write what is a need. Okay, so basically the tribunals will offer very cheap and easy mechanism to address the disputes in a given matter. Okay, so we need to write how it is different. So what is advantage? What is a need? So when we talk about need, you can write in the form of table also. It's not a matter. Okay, but presentation is a matter. So we can write here like this. Okay, tribunals, administrative tribunals versus judicial system. Right. So how do you explain what is the advantage, comparative advantage of administrative tribunals? So this provides the dispute resolution, in through simple procedures. Okay, here dispute resolution is complex. Dispute resolution is complex. Why it is simple? Because reason is it follows only substantive laws. Okay, whereas it follows both substantive laws and procedural laws. Substantive laws and procedural laws. And next, what else you can write? The administrative tribunals will be having experts. Okay, it means it will be having both the legal as well as technical members. Okay, it will be having only judicially trained persons. We can say they are called as judges. Right. And not only that, it provides informal procedure. It is extremely formal. Okay, this extreme formality may be a reason for pendency of cases. Right, but this informal procedure shall not be violating principles of natural justice. Guarantee, of course, the safeguard here is presence of informal principles of natural justice. These principles shall not be violated. Okay, right. Next, and these do not entertain much fee. So the cost of litigation is comparatively minimal. Comparatively minimal. Here cost of litigation is comparatively high. Comparatively high. Right? Not only that, there is another important point here is it provides quick resolution of disputes, and also these are highly accessible because certain tribunals are having the regional benches, example, because of their regional presence. Example, certain tribunals such as CAT has regional benches. Okay, and here dispute resolution is the matter. The major focus is on dispute resolution. Okay, right. Despite there is a guarantee for quality of justice, the proceedings we can say, or adjudication is relatively protracted. So these are the ways we can write the need for the administrative tribunals, right? So overall we can write certain points here. Thus, what is it? Administrative tribunals. Since administrative tribunals offer expertise, informal justice, easy accessibility, and sectoral presence. They offer advantages over the traditional judiciary. Okay, not only that, so he is asking need, right? So we can write some other points like in the context of LPG, where there is cutthroat competition across the countries, okay, across the countries over the matters of international trade, investments. Okay, right. Overall ease of doing business. Overall ease of doing business. Okay, there is a requirement of simplification of dispute resolution mechanism. Okay, right. So such dispute resolution not only with respect to administrative systems, like so such system has been facilitated not only in the matters of service condition, in the matters of service condition, but also in the various sectors of economic activities. Sectors of economic activities. So this is how we try to provide the need for the tribunals. Okay, we have written all these points, right? So we have differentiated how the tribunals are different from that of the judicial mechanism, like dispute resolution, simple procedure and complex procedure, because they follow substantive laws and they follow procedural laws as well as substantive laws. Expertise, legal and technical members, judicially trained persons here. Informal procedure, extremely formal, and no court fee. Okay, the cost of litigation is comparatively minimum, and cost of litigation is comparatively high. Quick resolution, they are highly accessible, despite there is a guarantee for quality of justice. Proceedings, or adjudication is relatively protracted, and since administrative tribunals offer expertise, informal justice, easy accessibility, and sectoral presence, they offer advantage over traditional judiciary. Particularly in the context of LPG, where there is cutthroat competition across the countries over matters of trade, international trade, investments, and over ease of doing business, there is a requirement of simplification of dispute resolution system, and such system has been facilitated not only in the matters of the service conditions, but also in the various sectors of economic activities. So this is how we need to write the answer. Okay. Then what else the examiner is asking? Assess the impact of recent tribunals reforms made in 2021, right? So actually we need to write, okay. So what is the Tribunals Reforms Act of 2021? Tribunals Reform Act of 2021. What is this act? Right. So this Tribunal Reform Act of 2021 was enacted, right? It was enacted in the context of Supreme Court's verdict, on Tribunals Reforms Ordinance of 2021. Okay, Tribunals Reforms Ordinance of 2021, where Supreme Court has invalidated certain sections, right? Then what is the need for this Tribunal Reforms Act? What is the need? Okay, the need for Tribunals Reforms Act. The purpose of Tribunals Reforms Act is that in India, almost all, because we have discussed what the advantages of tribunals, but however there is an increasing number of tribunals in the country across various sectors, okay, and in various sectors the tribunals started working as parallel judicial systems, okay. And Supreme Court, and moreover, not only working as parallel judicial system, slowly certain tribunals have reflected, slowly certain tribunals have reflected the similar flaws of flaws of judiciary. Similar flaws of judiciary. Okay. Supreme Court considered this as this particular trend, okay, as tribunalization of justice. Tribunalization of justice, where tribunals continue to dominate in the judicial matters. Okay, it means slowly and gradually more and more tribunals are getting into the space of the judiciary, because every sector, for every aspect, when you are creating the tribunals, definitely there will be some overlapping of tribunals with the judiciary, or there might be what is that under regulation or misgovernance of these tribunals. Okay, right. And moreover, you can write this also. Okay, due to this increasing trend of tribunals have highlighted certain flaws, certain problems. Okay, the increasing trend of tribunals has highlighted certain problems. So what are the problems? First one, fragmentation of justice. Okay, so where there was almost all 40 tribunals before the Tribunals Reforms Act, at the union level. Okay, fragmentation of justice. Number 2, huge pendency. Number 3, okay, for example, you take income tax, regarding the intellectual property appellate tribunal had too many vacancies, has too many vacancies, and also has too much pendencies. Okay, so when this intellectual property appellate tribunal was abolished by this particular Tribunal Reforms Act, the High Court started increasing the disposal of the income tax, intellectual property related matters in the efficient manner. Okay, the High Court could address the huge pendency that was there under the IPAT, right? And High Courts also have established their own benches regarding the intellectual property appellate tribunals and appellate matters, and High Court started disposing the matters so effectively. So huge pendency, and not only that, quality of justice was at compromise. Not only that, there are other problems, like for example, lack of uniformity in service conditions, and fifth one, lack of uniformity in retirement age, minimum age, okay, and also composition of the selection committee. So these are certain problems, and even Supreme Court also recommended the reforms related to the tribunals in the country in order to check the tendency of the tribunalization of justice. So where the matters are increasingly pushed under the domain of tribunals, and matters are being excluded from the sphere of the High Courts and Supreme Court, right? So this is how you try to provide a easy accessible mechanism, but however at the same time you are not able to guarantee the quality of justice. Okay, that's the reason why there is a requirement for amendment of this particular Tribunals Act. Okay, so enactment of the Tribunals Reforms Act, right? So then what are the features? Okay, so what are the features of Tribunals Reforms Act? What are the features? If we try to look at the features, first one, it ensures uniform service conditions uniform service conditions, so that every tribunal will be governed by similar service matters. Okay, clear specification of selection panel, where there is an involvement of both judicial members, judiciary as well as executive side. Okay, and number 3, abolition of 9 tribunals, okay, such as income tax, intellectual property appellate tribunal, we can say customs tribunal. Okay, similarly plant varieties related tribunal. Like this, there are 9 tribunals have been abolished, and their jurisdiction, okay, so their jurisdiction has been transferred to high courts. Okay, so their jurisdiction has been transferred to the high courts. Okay, and apart from that, it was also made that, okay, so the removal procedure, uniform removal procedure has been given, where removal is possible by government after consulting the selection committee. Okay, so this is so. Not only that, there were certain simplification of provisions, such as the eligibility to head CAT, Central Administrative Tribunal, okay, has been modified. Okay, how has it been modified? So there is no requirement of the status of retired judge of the High Court or Supreme Court judge. Rather, if a person has at least 3 years advocate practice, it is sufficient to hold the chairmanship of the CAT. Okay, right. And not only that, it tried to provide effective supervision of tribunals. Okay, so this is how there are various provisions added by means of Tribunals Reforms Act. These are the major and essential features, right? So actually, Supreme Court also in Madras Bar Association case held that there must be effective supervision of the tribunals in the country by establishing Tribunals Commission or National Commission on Tribunal. So we need to establish that, and so that there will be a kind of effective supervision, how they are working and what are the cases status, what is the pendency, okay, what is the efficiency, that will be monitored by a kind of independent body. But however, in the present situation, the administrative departments are having the supervision over the respective tribunals. So he has asked us to assess the impact of recent tribunals reforms made in 2021. So as far as the assessment is concerned, okay, this is how we are able to write the positive points, right? So now we need to write what are the negatives, what are the problems, okay, what are the problems associated with the Tribunals Reforms Act. Okay, first one, it has brought certain provisions back which were invalidated by by High Court in the ordinance, because before the enactment of this act there was an ordinance. Okay, so certain provisions were already invalidated by the judiciary. For example, you take the example of minimum age of 50 years that has been invalidated by judiciary, and tenure of the tribunal members to be 4 years, that was also invalidated by judiciary, because according to the judiciary's opinion, it does not bring independence for the tribunals. It does not bring independence for the tribunals, right? And coming to, so this act did not bring any independent authority, no independent authority to monitor the tribunals, okay? And moreover, by transferring certain matters by abolishing 9 tribunals will increase case burden, will increase burden of cases over, or burden of litigation, we can say, litigation over judiciary, burden of litigation over the judiciary. So these are the basic challenges, okay? And apart from that, there is also scope for delays in the adjudication, because when the tribunals were there, the tribunal's orders cannot be challenged in the court except when there is a clear violation of principles of natural justice. And but when you refer the matters to the High Court, what will happen? It will cause the delays in the adjudication. Why? Because naturally the High Court will take the time for the resolution of the disputes, but at the same time the matters from the High Court will be appealed to the Supreme Court. Further, the case burden or the delays will be increasing. So as you know, quite obviously, the cost of litigation increases. Okay. For example, you are able to understand in intellectual property appellate tribunal. If you try to take this, it is highly technical matter. Okay. High Court may not be having the technical understanding of the subject, and at the same time, this is such an important matter which is very, very important for the research ecosystem in the country, right? If the litigation is there, definitely research ecosystem cannot be developing to its full capacity. Okay, so this is another important challenge. Not only that, this Tribunals Reforms Act of 2021 did not establish, right? It did not establish any independent authority. What if it is not establishing an independent authority? Okay, the problem here is there is the problem of conflict of interest, and it is also violating the principles of natural justice, where no man shall be the judge of his own case. Why? Because suppose you take Ministry of Corporate Affairs, okay, it is having a tribunal called Company Law Tribunal. So this Company Law Tribunal, National Company Law Tribunal, which will be under the administrative supervision of the Ministry of Corporate Affairs, definitely there is a conflict of interest. You go to the tribunal challenging the administrative action, and simply it is under the nose of the ministry itself. Definitely it does not serve the interest of the justice. Okay, so that's why their supervision must be vested with some independent authority, but it is not there. Okay, so these are certain flaws associated with the Tribunals Reforms Act of 2021. Then, so we need to write some way forward. Okay, so what can be the way forward? Okay, right, way forward. Okay, so what is that? First of all, there must be rationalization of tribunal on need basis and reform must be comprehensive on the basis of data. Okay, next, there is a requirement of liberating tribunals from the executive control. Okay, next, what else we can write? Need for implementation of Supreme Court guidelines in Madras Bar Association case. Right, so there is also another important point. Okay, so the model of unified tribunal system of UK, the model of unified tribunal system of UK must be followed, because in UK also there was a problem of multiple tribunals. There was also a question of tribunalization of justice. They have reformed it to form a unified tribunal system, so that the multiplicity and overlapping jurisdiction of tribunals has been avoided and effectiveness of justice has been brought. So this is how we can write answer. Okay, right. So look at these dimensions. Okay, so we have written in a very comprehensive manner. Okay, so we written various dimensions. First of all, we written, as I told you already, so what is tribunal? Okay, administrative tribunals are quasi-judicial bodies which are considered under statute enacted by legislature, which offer the quick and cost-effective resolution of disputes in the administrative matters. So we have written, so this is what the context. Okay, then we explained about the need of the administrative tribunals in a proper manner, in a tabular form. So we have tried to differentiate how the administrative tribunals are different from that of the judicial system. Okay. Thereafter, we have written certain additional points. Particularly, we have tried to contextualize the tribunals. Okay. This is what the important aspect. And Tribunals Reforms Act, we have written what is a need. Okay. It was enacted in the context of Supreme Court verdict on Tribunals Reforms Ordinance in 2021, where Supreme Court has invalidated certain provisions. So need, there is an increasing number of tribunals in the country across various sectors, and the tribunals started working as parallel judicial systems. Slowly, certain tribunals reflected the similar flaws of the judiciary. Okay, so this is creating the. I mean, there is another important point. Supreme Court considered this particular creation of more and more tribunals as tribunalization of justice. So that's why there is an increased need for reform of the tribunals. For example, fragmentation of the justice, high pendency, quality of justice was compromised, lack of uniformity in retirement in minimum age, okay, service conditions, etc. And if you try to look at features of Tribunals Reforms Act, uniform service conditions, clear specification of selection panel, abolition of tribunals, like 9 tribunals have been abolished, and removal procedure, eligibility to head the CAT has been changed, and effective supervision of tribunals. Okay. And coming to the problems, it has brought certain provisions which were invalidated by Supreme Court. Sorry, it is not High Court, Supreme Court, in an ordinance. Independent authority to monitor the tribunals, lack of independent authority to monitor the tribunals. By transferring certain matters, by abolishing 9 tribunals, will increase the case burden of the judiciary. This will also increase the scope for adjudication, more litigation. The cost of litigation increases. It did not establish any independent authority to monitor the functioning of tribunals. I hope you understood. Okay. So if you have any specific queries regarding mentorship or any other reasons, please contact Epitome IAS. We are always ready to serve the needs of the students. Thank you so much.